Hi guys, good afternoon. Welcome back to another video with Pratham Test Prep. This is your host Sanjeet Bhatia again with a new video on your cases for your CLAT and AILET. All these cases have happened this year, so we will be discussing all of them in detail today. So if you are not a part of our channel yet, please do make sure that you are hitting on the like, share and subscribe button. And also make sure you don't forget to hit the bell icon so that you know when our live sessions are coming up. Okay, coming to the next part is that if you are looking for any Telegram queries, you can definitely join our channel under the name of CLAT@Pratham and they all will be solved, right? If you want to talk to us or you need any guidance, you can definitely give us a call or take personalized counseling. The number is mentioned under on your screen. That is 5 times 97592. That is the number you can call on us and you can definitely have a chat regarding your career options or what you should do, what are exams you should give, or any academic counseling that you require from our end regarding any courses are available under the same number. Right? So do give us a call if you're looking for any help, and do make sure that you are hitting on the like button. Now we are discussing the first news for the day. The first news for the day is regarding the Juvenile Justice Act. Now, Juvenile Justice Act is rare here. It is being discussed regarding the offenses prescribing max sentence of more than 7 years, but not providing minimum sentences are not heinous offenses but serious offenses, right? So, ये Juvenile Justice Act के अंदर बताया गया था कि जिन भी offenses का prescribed sentence या उनकी punishment is more than 7 years but not providing minimum sentence, कोई minimum sentence नहीं है तो वो heinous crime नहीं है, वो serious offenses हैं, right? Now here the person, the juvenile, obviously the name is not released here, is alleged to have committed a crime considered as a punishable offense under section 304, obviously murder. This was here is the brother of the deceased in the motor vehicle accident. The juvenile at the time when the incident happened was of 16 years. ठीक है जी, but not less than 18 years. So Juvenile Justice Board held that X has committed a heinous offense, therefore should be tried as an adult. Okay ji. So here his mother approached the High Court and which said that no minimum sentence is prescribed for the question. The said offense does not fall in the ambit of section 233 of the Juvenile Justice Care and Protection of Children Act of 2015, right? So this is also a very important case that you can see that the court has said that when there's no minimum sentence that is being provided, then it cannot be held as a heinous offense. Right now here the High Court was under the order of the High Court was under the challenge of in this appeal, and also the appeal was dismissed, saying that the issue of ambiguity in the act needs to be addressed in the parliament and that the court was not in the position to alter or add anything in this case, right? So this was regarding the Juvenile Justice Act that is there in our country regarding a person who was under a crime that was committed by him regarding accident where he was driving and he was 16 years of age, and the mother has approached the court to not to consider it as an heinous crime but to just consider it as a serious crime and not to be considered as an adult, right? So that is something which is really important in this case. Now coming to the next part, that is a child in conflict with law cannot be kept in jail or police lockup under any circumstances. This is what the Supreme Court has said कि कोई भी बच्चा जो कॉन्फ्लिक्ट ऑफ लॉ के अंदर है, राइट, कि मदर और फादर या कोई जेल में चले गए या डिवोर्स हो गया या समथिंग ऑफ दैट सॉर्ट हैज हैपेंड, सो दैट काइंड ऑफ अ चाइल्ड कैन नॉट बी केप्ट इन जेल और पुलिस लॉकअप अंडर एनी ऑफ these circumstances, right? Even if the bail is not granted, the child cannot be kept in police or lockup or jail, right? And has to be kept in an observation home or a place of safety, right? So that's what the Supreme Court has said. And also adding that the Juvenile Justice Board are not meant to be silent spectators, that the Juvenile Justice Board has to say something and they can't be silent spectators in such a case. Now, the next part is that the apex court also emphasized that a juvenile cannot be kept in jail or police lockup. Okay, That is very, very important. Such a person cannot be kept in jail or police lockup. Now, there was a bench that was comprising of Justice Deepak Gupta and Aniruddha Bose, made this observation after two instances were cited pertaining to certain allegations published in the media in connection to the child being purportedly detained and tortured in the police custody in Delhi and Uttar Pradesh. ठीक है, तो ये सब आपको पता है होता है हमारे कंट्री में कि टॉर्चर जेल्स के अंदर और थर्ड डिग्री टॉर्चर्स वगैरह is very common, and that too court tries to make sure that that doesn't happen with the people inside the custody. That is why if you read the evidence act also, if you see the confession, under the scheme of confession, if the person also gives a confession in front of a police, is not considered to be admissible in the court, right? He has to confess in front of the judge or in front of a magistrate, then only it will be considered as a confession. Okay, so now all juvenile justice boards in the country must follow the letter and the spirit of the provisions of the act, and we make it clear that the juvenile justice boards are not meant to be silent spectators. That's what the court has said, and orders only when a matter comes before them. Okay, said the court, citing the Juvenile Justice Care and Protection of Children Act of 2015 cannot be flouted, least of all by the police. Right, so that is something which is very, very important in this scenario. Now, coming to the next part, that is the proviso of the section of the act clearly lays down that a child alleged to be in a conflict with the law shall not be placed in a police lockup or lodged into a jail. Now, once a child is produced before the Juvenile Justice Board, the bail is the rule, right? It is a rule, you cannot deny it. It is a rule that you have to give the child a bail, right? Very simple, nothing very complicated in this. Now, coming to the next part is that the provision of the section clearly lays down that a child alleged is to be conflict with the law cannot be placed in the lockup. So आपको ये बात ध्यान रखनी है कि यहाँ पे नेचुरल जस्टिस के बारे में भी बात की जा रही है. इट्स नॉट जस्ट जुवेनाइल जस्टिस, ऑल्सो नेचुरल जस्टिस कि एक बच्चे को नहीं समझ में आता जेल के अंदर क्या क्या हो सकता है. दैट इज वाई दे हैव टू गिव हिम अ बेल. Okay, so that this is the case that was happening in the Supreme Court of India. Coming to the next case is that the governor can direct a floor test even in an ongoing assembly session, right? Floor test का मतलब कि चेक करना कि गवर्नमेंट के पास मेजॉरिटी है कि नहीं है. Now this has been done by the Supreme Court. The Supreme Court has endorsed the Madhya Pradesh Governor Lalji Tandon's direction to Kamal Nath government to face a floor test on March of 16th last year, following the resignations of 22 Congress MLAs, right, led by now BJP government made by Shivraj Singh Chauhan, and ruled that the governor had the power to direct the floor test on an ongoing session. ठीक है जी, चेक कर लिया मेजॉरिटी. Rejecting arguments of the senior advocates AM Sanghvi, Kapil Sibal, Vivek Tankha, and Dushyant Dave appeared for Congress. A bench of Justice D.Y. Chandrachud and Hemant Gupta said that a governor is not dedued of the power to order a floor test where, on the basis of the material available, it becomes evident that the issue as to whether government commands the confidence of the House required to be assessed on the basis of a floor test, right? So that is what the Supreme Court has also said, that there has to be a floor test to check that there is the confidence in the House also present, right? So this is something that the Supreme Court has also observed, and there was a huge panel of lawyers who was fighting this case for BJP government in Madhya Pradesh. As you know, there was a lot of drama that has happened in the politics of Madhya Pradesh because Mr. Kamal Nath from the Congress party was the chief minister of Madhya Pradesh, and he was removed because he could not prove his majority under the floor test. So that is something which is really, really important. You need to see that these kinds of things can change the entire politics of a state. Right now, the government is under Shivraj Singh Chauhan, and he is leading the state right now at this hour. Coming to the next part for the day, that is that the daughters have the co-parental rights even if their fathers was not alive, if their father was not alive when Hindu Succession Amendment Act of 2005 came into force. So that's what we have discussed in our legal terms also. I have discussed the legal terms that all the laws cannot be put up in retrospective effect, right? None of the laws can be put into retrospective effect, but prospective effect. But आप देखिए, मैंने आपको ये भी बताया था जो beneficial laws in nature होते हैं वो रेट्रोस्पेक्टिव इफेक्ट में भी लगाए जा सकते हैं, राइट? सो रेट्रोस्पेक्टिव इफेक्ट के अंदर अगर ये लॉ को लगाया जा रहा है, सो देखिए तो सारी हिंदू daughters, yeah, all the daughters who were there will get an equal right in their father's property, right? Even if their fathers were not present and when the act was passed in 2005, right? So what did the court has said? That the conferral of the right is by birth and the rights are given in the same manner with incidents of co-partnery as that of a son, and she is treated as a co-partner in the same manner with the same rights if she had been a son at the time of birth. So you can see that the court is also very clear in putting a retrospective effect to it, and also they are giving a full right to the females for having a equal right in the property of their fathers, as if that even if they were dead before 2005. So there is a retrospective effect in this act, which is very very good because it is beneficial in nature and women are being considered equal in the society. Now co-partnery property is the one which is inherited by a Hindu from his father, grandfather, or great grandfather, right? So, ऐसा नहीं है, right? That a person who is just got married, his wife can ask for a co-passing, or he can ask, or she can ask for the property of their own grandfather. They can ask it. If their own father dies, then they can ask for it, otherwise they cannot, right? So that's what it was earlier, that they couldn't ask any rights in the property of fathers, great grandfathers, or grandfathers. So that was a problem that was being faced by the Indian females for a very long time, but this act has made it pretty clear for all the women. Now, as earlier women could not be a co-partner, but she could be a joint family member. Now but substituting section 6 from effect from 9/9/2005, daughters are recognized as co-partners in their right by birth in the family like a son. Okay, co-partnery is the creation of law. Only a co-partner has the right to demand partition. Test if a person can demand a partition, he is a co-partner or not, otherwise. Okay, so this is a very very simple case that has come up in front of us regarding the daughters status in our country, and also providing them equal rights in the property of their fathers. Now this was the act which came into force in 2005, and there is a retrospective effect, and you can see even if the father was not alive in 2005 when the act was passed, they still get equal rights in the property of their fathers, right? So which is a good deal for all the people in the country, and also provides equality of rights for all the people, and rather male or female doesn't matter. Chaliye, coming to the next part for the day, that is candidates belonging to the reserve category eligible for general category vacancies based on merit, right? So ये भी सुप्रीम कोर्ट ने बताया है कि अगर एक प्ली फाइल हुई थी यहाँ पे, वहां पे दो कैंडिडेट्स थे जिन्होंने एक I'm really sorry, पास प्रोसेस सिलेक्शन प्रोसेस कंडक्ट हुआ था स्टेट ऑफ उत्तर प्रदेश के लिए फॉर द पोस्ट ऑफ पुलिस कांस्टेबल्स, राइट? अब इस पिटिशन के अंदर क्या है कि पोस्ट ऑफ जनरल कैटेगरी फीमेल कैंडिडेट्स वर रिजेक्टेड बिकॉज इफ दे बिलोंग टू द कैटेगरी ऑफ वर्टिकल रिजर्वेशन, दैट इज ओबीसी, एससी एंड एसटी एक्सेट्रा. Now the Justice Uday Umesh Lalit and Justice S Ravindra Bhatt and Rishikesh Rao were hearing the plea. Now the court held that it is a well settled principle that the candidates belonging from the vertical reserve category is eligible to get selected on open or general category, right? If the candidates belonging to the reserve category is eligible to be chosen on the basis of his or own merits, the placements of the candidates cannot be counted against the quota reserved for vertical reservation category to which the candidate belongs. ठीक है, तो वो यही कह रहे हैं अगर आप मेरिट लेके आते हो तो आप मेरिट में जाके पढ़ सकते हो, बट नहीं लेते तो आप कोटा क्लेम कर सकते हो, बट अगर आप ले आए हो तो आप ओपन कैटेगरी में जाके पढ़ सकते हो, और ये कैन नॉट बी काउंटेड अगेंस्ट द कोटा, राइट? तो ये एक बहुत डिसीजन दिया गया है. सिंपल, अब आप जैसा इसको समझे, बट दैट्स व्हाट द सुप्रीम कोर्ट थिंक्स रिगार्डिंग द रिजर्वेशन, एंड दिस वाज द केस रिगार्डिंग सिलेक्शन ऑफ पुलिस कांस्टेबल्स इन उत्तर प्रदेश. ठीक है जी. सो दिस इज व्हाट द केस इज. Coming to the next part for the day, that is Indira Gandhi versus Raj Narayan. That is the case of 1975, the trigger that led to the imposition of emergency in our country. Now, this was a case regarding the election dispute. The primary dispute was regarding the validity of Clause 4 of the 39th Amendment Act of the Supreme Court, held that Clause 4 as unconstitutional and void on the ground that it was outright denial of the right to equality enshrined in Article 14. Now, the Supreme Court also added that the following features as basic features laid down in Keshwan and Bharti case: democracy, judicial review, law, and jurisdiction of the Supreme Court under Article 32. So this was a very, very old case which triggered imposition of emergency in our country. So definitely it becomes very important for your CLAT and AILET examinations also. Coming to the next case for the day, that is a step backwards for India. That is ADM Jabalpur versus Shivkanshukla case. If you are going to a law school, you will definitely be studying all of these cases very, very regularly. So do get ready for that. Widely considered a violation of fundamental right, in this landmark judgment, the Supreme Court declared that the rights of the citizen to move to court uh, for violation of Article 14, 21, and 22 would remain suspended during emergencies. Right? So that's what the court has said. Okay, so this was a step backwards for India. Now the next is that the constitutional validity of individual rights was upheld. Woman Rao versus Union of India. The Supreme Court ruled that the Parliament has transgressed its power of constitutional amendments. ठीक है जी. The case was a landmark decision that in the constitutional jurisprudence of India, the case helped in determining satisfactory methods of addressing grievances. जो भी problems होती थी उनका एक method, satisfactory method provide किया गया to the violation of fundamental rights by creating a fine line to determine between the acts prior to and after Keshwan and Bharti case. ठीक है जी. तो आप केशवन एंड भारती केस जरूर पढ़ें, एंड दैट इज समथिंग दैट आई विल रेकमेंड ऑल ऑफ यू. if you are going for a law school examination, you should definitely read Keshwan and Bharti. चलिए, तो मेंटेनेंस लॉसूट प्रेसिडेंट, दैट इज मोहम्मद अहमद खान वर्सेस शाहबानो बेगम. शाहबानो केस वाज वेरी वेरी फेमस, where the Muslim woman Shahbano won the right to get alimony from her husband. Now it was a challenge on the Muslim personal law. The Supreme Court ruled in the favor of Shahbano and granted her alimony, most favored as it secured judgment, but also invoked a strong revocation from the Muslim community, which felt that the judgment was an encroachment on Muslim Sharia law, hence led to a formation of All India Personal Law Board in 1973 in our country. Coming to the next case for the day, that is the foundation of the female workforce with Vishakha versus state of Rajasthan. यहाँ पे आपको विशाखा गाइडलाइंस के बारे में बहुत सुनाई देगा if you talk about sexual harassment in workplace. Now the definition of sexual harassment and the guidelines were laid down in this case, and also the Vishakha and other women groups filed a PIL against the state of Rajasthan and the Union of India to enforce the fundamental rights for working women under Article 14, 19, and 21 of the Constitution, which resulted in introduction of Vishakha guidelines. Right. Also, the judgment of August of 1997 also provided basic definitions of sexual harassment at the workplace and provided guidelines to deal with it. कि कमिटी बनानी चाहिए, उसके अंदर 2 women होनी चाहिए, जो भी सारे उसके requirements है आप पढ़ सकते हैं. Hence the requirement of the importance of the case as landmark judgment. ठीक है जी. Vishakha guidelines is something really, really important for you guys. Section 377 is the Nas Foundation case versus the government of NCT Delhi. This is a cause for rejoice for homosexuals. 377 was repealed in this on this case. In 2009, the Supreme Court has declared Section 377 of the Indian Penal Code as unconstitutional, and also said that criminalized sexual activities against the order of nature, which included homosexual acts. This judgment, however, was overturned by the Supreme Court in December of 2013. Chaliye. Next is NOTA judgment. Now, this is the Public Union for Civil Liberties and Others versus Union of India. The right to reject candidates formalized in 2013. The Supreme Court has also introduced the button of NOTA, that is none of the above, if they don't find any candidates worthy of their vote in any elections, right? Now, illegalizing the convicted MPs and MLAs. Now, this is Lily Thomas versus Union of India, that is effected much needed cleansing of legislative bodies. And also the Supreme Court of India in this judgment ruled that any member of the parliament, also legislative assembly or legislative council, who has been convicted or and awarded a minimum of 2 years of imprisonment would lose the membership of the house with immediate effect, right? So that's what the court has also said in this case. Now, recognition to the third gender is coming from National Legal Services Authority versus Union of India. That is a case for April in 2014, where the Supreme Court in April 2014 recognized transgender person as third gender and also ordered the government to treat them as minorities and extend reservation in jobs, education, and other amenities. Okay, ji. So that is it for today, guys. So I hope you were able to get some cases. I've discussed it very, very quickly for you guys to not waste a lot of time in reading all of these cases, and you can get a quick overview regarding all of them. So do read all of these cases and also stay safe and stay healthy, because you know the new variant for Omicron have entered our country. So definitely make sure that you are wearing your mask and using your hand sanitizers and also maintaining social distancing. Please wash your hands regularly and make sure that you are not going outside a lot and taking care of your health and yourself. So keep smiling and keep preparing. Thank you for joining the live session. Hope to see you soon on Friday again with a value added session. Take care of yourself and have a nice day, all of you.